The process, of course, will vary greatly depending on each individual case. The process can be long or short, dependent, of course, on the defendant's response to any potential claim. The importance is, however, to ensure that the family understand that and that there are reasons for the fact that a claim such as this is inevitably lengthy, and that they are fully on board with us and understand the reasoning behind the timings. In terms of the families themselves, obviously we need information from them in relation to the circumstances surrounding the labour, delivery, etc. If that is when we feel the cerebral palsy arose, we will need certainly in-depth information from them in relation to how their child's condition is impacting on both the child and the family as a whole. That is important, but certainly from my point of view, when dealing with families, I do try and alleviate the pressure on them somewhat in relation to the evidence they provide by explaining to them that what's key to this litigation is in fact the medical evidence, and that is what more often than not will determine the outcome of litigation. So the family's evidence is important, but it is not perhaps as high pressured as families may feel, and this is what I try to make clear to them. I have been specialising now solely in clinical negligence for 25 years, and if I say I've been to 3 trials, that may even be an exaggeration. That's an indication of how rarely these matters will in fact go to trial. The issues are complex and the stakes are very, very high for both claimant and defendant. On that basis, generally there will be some meeting of the parties following expert opinion, and that will result in some sort of negotiated settlement or an admission, and very, very rarely a withdrawal on our behalf. So trials are unusual.